Good morning, everyone. I am Shruti Kriti, National Secretary of NPNLC, and it's my pleasure to welcome you all to this online lecture. I would like to introduce our distinguished guest and also acknowledge the esteemed leadership of our National President Advocate Jayaprakash Somani. NPNLC began its journey in 2022 under Advocate Somani's leadership. With over 3 decades of experience, he is a renowned advocate at the Supreme Court of India, an author and legal expert. His contribution to the legal fraternity are immense, and his firm, JSAS, has established itself as a prominent name in the legal domain. Advocate Somani's commitment to making legal services more accessible and affordable is truly commendable. His free guidance camp and literally contribution, including approximately 65 books on Supreme Court case laws, are a testament to his dedication. Now, our national president, Advocate Jayaprakash Somani, will introduce today's our speaker. Over to Advocate Jayaprakash B. Somani. Thank you, sir.
Thank you. Thank you, Shruti, for your kind words. Friends, today's lecture is on protection of women's rights under the Indian laws by our esteemed guest, Senior Advocate Rachana Srivastava. Very few advocates get the designation as a Senior Advocate from Supreme Court of India, and Rachana is from one of them. Rachana is my very good friend in Supreme Court, but his all-round personality, I want to explain you through some brief information. I don't want to cut down that information because people and legal luminaries and legal law students, advocates of India should know who is the Senior Advocate Rachana Srivastava and how she has rising from a lawyer to senior designated advocate, and how this journey was happened. So let me give you some the insight of her personality and her legal practice also. Her academic qualification in MA English Literature, completed her LLB from Allahabad University, First Division, proficiency and diploma in French language, Allahabad University. She has been practicing in the Supreme Court of India and had secured second position in Advocate on Record examination conducted by the Supreme Court in the year 1999 and was awarded Silver Medal by the Chief Justice of India. She was designated as a Senior Advocate by the Supreme Court of India. She has appeared in several important cases successfully in the Supreme Court, including the Constitutional Bench, which are all reported cases. She had been the standing counsel for the state of Uttarakhand in Supreme Court since 2001 till designation as a Senior Advocate. Also, additional Advocate General for the state of Uttarakhand in the Supreme Court of India. Also, she had been Special Counsel for Land and Building Department, Government of NCT of Delhi in the Supreme Court since 2002 till designation as a Senior Advocate. She has been office bearer of the Supreme Court Bar Association for 2 consecutive years as Assistant Treasurer, owned by the record margin of votes recorded still intact. Record is still intact. Nobody has broken that record. Elected Treasurer was elected as the senior member executive in the Supreme Court Bar Association, and Vice President of the Supreme Court Bar Association had been Honorary General Secretary of the Bar Association of India. She has participated in several national and international conferences for the past many years, including Lavasa Conference held in Siem Reap, Colombia, Bangkok, Thailand, and Commonwealth Law Conferences held in Cape Town, South Africa. She has presented paper and delivered lectures on the issues pertaining to the environment, business, child rights, and on elders in several international conferences, including the Lavasa conferences held in Penang, Malaysia, Sapporo, Japan, Sydney, Australia, Colombo, Sri Lanka, and the Commonwealth Law Conference held in Glasgow, Scotland, and Livingston, Zambia. Apology for pronunciation because that foreign city's name may be a little bit wrong. Mrs. Rachana is a founder member of BRICS Legal Forum and has been part of the delegation in all the conferences meet of BRICS Legal Forum held in Brazil, Shanghai, Brazil, and then Shanghai, China, and Moscow, Russia meet. She was a member of the delegation of lawyers from India who had attended a spring meet in 2017 in Washington at the invitation of the American Bar Association. She has judged several national and international moot courts competition. So, Rachnaji, I want to share you something. With the grace of Lord Krishna and with the blessing of my Guru Nani Palkhiwala, I am able to publish more than 65 books on Supreme Court case laws. And in that, today's subject, our protection of women's right. On women's right, DV Act, some leading cases book is there. Then once 376 book is there. On maintenance of women's right book is there. So many women protection laws books are there, along with all other books also there. And we from the platform of Nani Palkhiwala National Law Club, we have 15 to 16 different WhatsApp groups on the name of Nani Palkhiwala National Law Group, and one of the group is a women's right group is also there, and Shruti is leading that group. So, so this is just sharing you because we are friend, but we are just discussing law matter, legal matter, but we are not discussing each other's career or each other's participation in this legal field. So I want to share that. And let me assure audience, you will get enlightened on today's subject from my friend, senior advocate Rachana Srivastava. Over to ma'am. Thank you.
Thank you, Somaniji, for your kind words. And you've been very generous with the introduction. Thank you so very much. And I really feel honored and privileged to be part of this club today, presenting my lecture. Because Nani Palkhiwala, I think he was a legend, and I think he's Bhishma Pitama for all of us who are in the legal field. So he is Guru, and with his guidance, eternal guidance, and blessings, heavenly blessings, I think we all pursue what he stood for. He stood for liberty. He stood for freedom of speech. So that's the best tribute that you have initiated this lecture series by this Nani Palkhiwala National Law Club. And I'm told there is a large number of participants. They are members of this club, and it is open to all. I saw the Shruti's message also that people can join there, and you're giving free services also to many. So that's an incredible thing that you are doing, and my compliment to you.
Thank you.
And you are an expert on this field. So why did you invite me? You have written books. So my lecture is going to be more general in nature because lawyers, they all study everything, but this will be helpful for others also, not just lawyers. So I thought that on a broader perspective, because lawyers in any case will go through the judgments and read anything, but for what is should be known by the common person, I have kept that in mind, and in a broader way, I have just outlined my lecture. I've broken down it in 4 parts, and primarily first part will be the introduction, and then the constitutional foundations. Then second part would be a statutory framework and some judgments, and then some contemporary challenges in a nutshell. So to begin with, I would say that the story of women's rights in India is a long and a complex journey. one that has traversed from the ancient reverence to the medieval repression, from colonial codification to constitutional transformation. Well, in India, the women were described as Ardhangani. Nice to hear that. Equal half of man, embodying power of Shakti and wisdom, Saraswati. But over the centuries, we see the social customs and patriarchal structures that has eroded this dignity. By 19th century, women were denied education, property, even basic autonomy. It was in this context that reformers like Raja Ramohan Rai, Ishwar Chand Vidyasagar, and later Dr. Ambedkar emerged as a torchbearer of social justice, embedding that no society can progress if half of its population is shackled. Dr. Ambedkar, the principal architect of the Constitution, he had declared, and I quote, "I measure the progress of a community by the degree of progress which women have achieved." And this vision was not merely moral, it was constitutional. It laid the foundation for a legal edifice of women's equality in India. I'll briefly mention the constitutional vision that Dr. Ambedkar shared. The Constitution, as we all know, was adopted in 1950. It stands as a cornerstone of the women's rights. It does not confer equality as a charity, but it guarantees justice. The heart of this guarantee lies in Article 14, that ensures equality before the law and equal protection of the laws. Complementing this Article 14 is Article 15(1), that prohibits discrimination on the grounds of sex, whereas Article 15(3) empowers the state to make special provisions for women and children. That's a constitutional recognition that equality sometimes requires affirmation action. Similarly, Article 16 extends the right to equality in public employment, whereas Article 39A and D of the Directive Principles of the State Policy mandate equal opportunity and equal pay for equal work. Article 42 directs the state to ensure just and human conditions of work and maternity relief. That is the first constitutional acknowledgement of working women's reproductive rights. In the case of Air India versus Nargesh Mirza, 1981 4 SCC 335, Supreme Court struck down discriminatory service regulation that forced air hostesses to retire on marriage or pregnancy. The court held that policy as arbitrary and violative of Article 14 and 15, affirming that the concept of equality of our Constitution is substantive and not formal. The duties in Article 51(a)(e) of the Constitution imposes upon every citizen the duty to renounce practice derogatory to the dignity of women. This insertion through 42nd Amendment reflected a maturing constitutional morality. It was a shift from viewing women as dependents to recognizing them as equal participants in the moral and civic life of the nation. I will briefly mention about the statutory provisions that protect women's rights. The first and foremost comes the Protection of Women from Domestic Violence Act, 2005. This act defines that domestic violence is not just a physical abuse, it includes emotional, sexual, and economic abuse as well. It's a lack of awareness that many times the women are not aware of their legal remedies and right to protection, that they endure these sufferings. Section 3 of the Act defines domestic violence to include physical, emotional, sexual, and economic abuse. Section 18 grants protection orders preventing an abuser from causing further harm. Section 19 ensures residence rights, allowing a woman to stay in her matrimonial home, whereas Section 20 and 22 provide financial compensation, maintenance, and damages to the victim. The next important act is the Dowry Prohibition Act. Despite these legal prohibitions, we see often the dowry-related harassment and that continue to occur. Therefore, it is necessary for the women to understand their rights to refuse dowry demands and take legal action against the perpetrators. Section 3 penalizes giving and taking dowry with imprisonment up to 5 years and fine. Section 4 of the Act criminalizes demands for dowry . So the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. As we all know, this is the culmination of Vishaka judgment. After delivery of this judgment, after 13 years of this judgment, Vishaka judgment, this act was enacted and it came into effect in the year 2014. Section 2 of this act defines sexual harassment as unwelcome advances, remarks, and physical contact, whereas Section 14 mandates that every workplace with 10 plus employees should set up an internal complaints committee. And Section 9 of the Act provides a mechanism for filing complaints confidentially. Next important act is the Hindu Succession Act. These are the acts I'm referring to that every woman should know in a nutshell. Many women are denied their rightful share in family property due to outdated customs, and legal awareness helps women claim their inheritance. So Section 6A grants daughters equal rights in ancestral property, whereas Section 14 recognizes a woman's absolute ownership of her property, and Section 15 ensures a woman's heirs inherit her self-acquired assets. The Muslim Women Protection of Rights on Marriage Act 2019, this was enacted after the triple talaq was struck down by the Supreme Court, because that was the, I would say, many Muslim women suffered because of the instant triple talaq. So this law provides legal protection against that arbitrary divorce. Section 3 of the Act criminalizes instant triple talaq, talaq-e-biddat, and Section 5 ensures maintenance for divorced Muslim women. Then comes the Maternity Benefit Act, 1961. Many women are unaware of this right to paid maternity leave and workplace support during pregnancy. Section 6 of this Act grants women 26 weeks of paid maternity leave, and Section 11A mandates a creche facilities for establishment with 50 plus employees. Section 12 of this Act protects women from termination due to pregnancy. Then there is another act, the Equal Remuneration Act of 1976. Its principles remain crucial for ensuring workplace equality. Section 4 mandated that employers provide equal pay for equal work regardless of their gender. Section 5 prohibited gender discrimination in recruitment and promotion. No exemption from the Act can be claimed by an employer on the ground of financial incapability. So this is mandatory to be absolutely adhered to. The most important is the protection granted under the criminal laws. Bharatiya Nagrik Suraksha Sanhita and Bharatiya Nyaya Sanhita, the new acts which have come into force after repeal of old criminal laws, IPC and CRPC, and Evidence Act. So Section 69 of the BNS that criminalizes sexual intercourse under deceitful means, including false promises of marriage, that is with punishment up to 10 years imprisonment and a fine. Section 78 of BNS defines stalking as a man's repeated attempts to contact a woman despite her clear disinterest or monitoring her electronic communications. Exceptions, of course, include actions for crime prevention, legal compliance, and other justified circumstances. And the penalty ranges from up to 3 years imprisonment and fine for the first conviction, of up to 5 years imprisonment and fines for subsequent conviction. Section 85 of BNS is if a husband or his relatives subject a woman to cruelty, they can face imprisonment of up to 3 years and a fine. This provision aims to protect women from domestic violence, harassment, and abuse within marriage, reinforcing legal consequences for mistreatment by in-laws and spouses. Section 184 of BNSS provides for a medical examination of a rape victim or victim of an attempt to rape that must be conducted by a registered medical practitioner in a government or a local authority hospital within 24 hours of receiving information with the victim's consent and that of an authorized person. The medical report must include the victim's details, injuries, mental condition, and material for DNA profiling, along with the reasons for conclusions and time of examination. The report must be forwarded to the investigating officer within 7 days, who will submit it to the magistrate. No examination can be conducted without the consent of the victim. One of the most important section of BNSS is 179, which every woman should know, that women cannot be compelled to appear at a police station or any other place outside their residence for questioning during an investigation. Instead, their statement must be recorded at their place of residence, ensuring their safety and convenience. However, if a woman willingly chooses to attend the police station, that she can be permitted to do so.
Very nice provision is this. Very
Yes.
nice provision. Yes.
And every lady, every woman should know, should be aware of this particular provision.
Yes.
People are not aware. People just go away because they call and they go. So they should assure this. Then there's another important act, Legal Service Authorities Act. That is for the women from the marginalized communities. They often struggle to afford legal representation. Section 12 grants free legal aid to women, children, and economically weaker sections. I'll come to some judicial interpretations of these provisions. In the, I think, earliest year of this constitutional adjudication, the judiciary has, in CB Muthamma versus Union of India case, 1979, AI 1979, 1868. So dowry and domestic violence, I have already mentioned. And Kansraj versus State of Punjab in 2000, Supreme Court lamented that the continuing and barbaric practice of dowry death that urge for stringent enforcement. But still, these acts actually have also been misused. So therefore, the Supreme Court has an occasion to call for a balance. And then this judgment in Arnesh Kumar versus State of Bihar, the court directed the police restrain and arrest under section 498A of the previous act, IPC. Because in the police complaint, the entire family was used to be robbed in. The in-laws, the brothers, sisters who do not even live together, who are living abroad, they were all robbed in. So this was the balance. This was the balance that was created by the Supreme Court. But there was a paradigm shift in complementing criminal law, the Protection of Women from Domestic Violence Act. This defined domestic violence broadly to include physical, emotional, and sexual and economic abuse. And as I already mentioned earlier, that introduced civil remedies such as protection orders, residence rights, and maintenance, etc. In this act, the Supreme Court widened the definition of respondent. In Hiralal Harsova versus Kusum Narottam Harsova, the Supreme Court included female relatives of the husband, ensuring that no perpetrator escapes accountability merely due to gender. I have already mentioned about the sexual harassment workplace safety, but I would repeat that this is one of the most celebrated developments in women's rights in the judicial genesis. This gave to the enactment of sexual harassment of women at workplace, Prohibition, Prevention, Redressal Act 2013. This was triggered by a gang rape of one Bhavari Devi, and the Vishaka guidelines recognized that sexual harassment violates Article 14, 15, and 21. Justice Sujata Manohar wrote, gender equality includes protection from sexual harassment and right to work with dignity. So 2013 Act codified these principles and therefore mandated internal complaints committee, gender sensitization, and confidentiality in these proceedings. And subsequently, in Medha Kotwal Lele versus Union of India, this was affirmed that every institution has to have these committees in place. The Criminal Law Amendment Act 2013 was outcome of a very unfortunate incident, Nirbhaya incident, as known, that revolutionized sexual offense laws, that expanded the definition of rape under Section 375 IPC and introduced new offenses like stalking, voyeurism, and enhancing penalties under Section 376A E of the previous act, which is now stands repealed. In state of Punjab versus Gurmeet Singh, Supreme Court had warned against victim blaming, stating that testimony of a victim of sexual assault is vital and should be treated as evidence of sterling quality. Another act, that POCSO, the Protection of Children from Sexual Offenses, further strengthened protection of minors, ensuring child-friendly procedure and severe punishment for abuse. All these enactments collectively reaffirm the right to bodily integrity and dignity is totally non-negotiable. Then we come to economic and labor rights. I have earlier mentioned the Equal Remuneration Act, which was enacted to eliminate gender-based wage disparities. The principle of equal pay for equal work was read into Article 14 by Supreme Court in Randhir Singh versus Union of India in 1982. Later in McKinsey and Company versus Audrey D. Costa, the Supreme Court applied the act to correct discriminatory pay practices in private firms underscoring that economic justice is an inseparable element of gender justice. I've recently come across an interview by a Hollywood actress who said that she still gets 50% less than what her male counterparts in the film industry is paid.
Surprising.
It is surprising. The famous Sharon Stone said that, that she is still paid. So that gender disparity exists not just in India, but elsewhere also. But India is actually taking care of that. But
Yes.
abroad in other countries, it is not so. Then Maternity Benefit Act ensures paid leave and safeguard against dismissal during maternity. And 2017 amendment extended maternity leave to 26 weeks and introduced creche facilities aligning with the Article 42's directive for human working conditions. In Municipal Corporation of Delhi versus female workers, Supreme Court held that even daily wage workers are entitled to maternity benefits, declaring that motherhood is not a liability, it is the essence of life itself. Then Factories Act 1948 and the Shop Establishment Acts across the states further regulate safety, working hours, and health provisions for women workers. Then there is another act, Immoral Traffic Act 1956, that criminalizes trafficking and exploitation of prostitution. Complementary to this, the Bonded Labor Abolition Act 1976 and Juvenile Justice, Care and Protection of Children Act 2015 offer safeguards for vulnerable women and minors. Supreme Court in Gaurav Jain versus Union of India in 1997 called for a rehabilitative rather than punitive measures for sex workers, holding that Constitution envisions not condemnation but compassion. Legal empowerment is incomplete without a political voice. The 73rd and 74th Constitutional Amendment 1992 reserved 1/3 of seats for women in Panchayat Raj and urban local bodies. This has transformed governance at the grassroots, with women now comprising over 14 lakhs representative nationwide. Cases like Vijay Lakshmi versus State of Tamil Nadu upheld that such reservation as an instrument of true democracy. Parliament is still debating women's reservation bill and hope this will extend this reservation to legislature. And this step could actually finally bridge the gap between constitutional promise and the political reality. If there is a will, there is a way. I hope that by next session it will be passed. We are still hoping for that.
Yes.
Then comes the Right of Children to Free and Compulsory Education Act and National Food Security Act that also incorporate gender-sensitive provisions, ensuring that girls are not left behind in the education or nutrition. Another important act, the Preconception and Prenatal Diagnostic Technique, Prohibition of Sex Selection Act, that combats female infanticide, while the medical termination of pregnancy extended abortion right up to 24 weeks in certain cases, a recognition of reproductive autonomy under Article 21. In Rachana Srivastava versus Chandigarh administration, Supreme Court held that a woman's right to make reproductive choice is a dimension of personal liberty. So each of these enactments, from family law to workplace safety, from maternity benefit to reproductive autonomy, they tell a single story. Indian state has moved from paternalistic protection to participatory empowerment. Dr. Ambedkar rightly warned, I quote, "Rights are not protected by law alone. They are protected." I missed that quote.
Unless and until society upheld that.
Oh, that is the quote.
Yes.
Yes, yes.
Society should uphold that rights.
Yes,
Society should give the honor to the woman. And in a house where woman respect is there, so
yes,
Lakshmi and Saraswati will be there always. So there
yes.
should be a respect of woman.
Correct,
Yes.
correct. So likewise, the Shaira Bano judgment marked the watershed moment for Muslim women's rights.
Yes,
So
yes.
petitioner Shaira Bano challenged the practice of talaq-e-biddat, instant triple talaq, which allowed Muslim women to divorce their wives unilaterally. So the 5 judgment held, and this judgment was followed by Muslim Women Protection of Rights of Marriage Act 2019, that criminalizing this practice. It reflected a powerful synergy between judicial activism and legislative reform. In Joseph Shine versus Union of India, adultery law was dismantled, as over a century, Section 497 of IPC was treated adultery as an offense committed by a man against another man's property, his wife. So women were excluded from prosecution or agency, seen as merely a passive participants. So the Supreme Court in this Joseph Shine struck down this archaic provision and held it to be unconstitutional and violative of Article 14, 15, and 21. Justice Chandrachud's quote is important. He has said, "A woman cannot be asked to think as a man or behave like a man. Society must learn to view her as an equal citizen capable of making her own choices." So the court recognized that marriage is a partnership of equals, not of patriarchal control of. So the judgment exemplified feminist constitutionalism in action. In Independent Thought versus Union of India, the case examined the exception to Section 375, which allowed, that's a very important judgment, that allowed marital intercourse with the wife aged between 15 and 18. The Supreme Court read down this exception, holding that sexual intercourse with the minor wife amounts to rape. This judgment harmonized in protection of children from Sexual Offences Act with IPC, ensuring no minor girl, married or not, could be denied protection from sexual abuse. The court, Justice Lokur, emphasized that constitutional rights cannot be suspended within marriage, declaring a child remains a child irrespective of her marital status. So this was a crucial assertion on bodily autonomy and right to dignity under Article 21. Then there is another judgment in Nalsa versus Union of India, 2014, where the court profoundly advanced gender equality by recognizing transgender persons as a third gender and affirming their right to self-identification. This judgment broadened the discourse on women's rights by acknowledging intersectionality of gender, sexuality, and identity. It's vital lessons for the advocates of new era, the new generation.
Yes.
In Charu Khurana, Supreme Court struck down rule of that I have already mentioned about the makeup artist. The court said, and I'll quote Justice Sikri's judgment, "To call a woman unfit for a profession by reason of her gender is to insult the Constitution itself." The Nirbhaya case I've already mentioned. Vinita Sharma is also mentioned. Another judgment is X versus the Principal Secretary Health, that expanding the reproductive autonomy, where the Supreme Court held the Supreme Court interpreted the Medical Termination of Pregnancy Act to include unmarried women within the scope of abortion rights up to 24 weeks. That's an important judgment. There again, Justice Chandrachud's observation that the right to reproductive autonomy is an inseparable part of the right to personal liberty under Article 21. That was a very progressive interpretation, recognizing women's choices regarding their bodies, relationships, and that future cannot be subject to the societal approval.
Yes. Yes.
So the Justice Chanchur's quote is that right to reproductive autonomy is inseparable part of the right to personal liberty under Article 21. So the collective impact is that across decades, these rulings built a feminist constitutional jurisprudence that one recognizes women as an individual and not dependent needing protection.
Mhm.
So that's a change over the years we have seen through these judgments. And Justice Krishna Iyer wrote long ago that law without justice is a wound without remedy. For women, it must be the bridge from silence to speech. So each judgment has moved the nation closer to that bridge, transforming constitutional equality into lived equality. So these are the things. But I want to flag some challenges for my young friends. They have to carry forward this. So what is the unfinished agenda of equality? So even after 7 decades of constitutional democracy, the journey towards full equality for women remains incomplete. Though the law has moved swiftly, society more slowly. Despite progressive legislation and judicial intervention, women continue to face discrimination in workplace, unequal access to property, underrepresentation in politics, and widespread gender-biased violence. The National Crime Record Bureau reports alarming rates of crimes against women, from domestic violence to cyber harassment. The labor force participation rate of women hovers around 25%, among the lowest globally. But women's representation in higher judiciary, parliament remains far below parity. Many progressive laws that I talked about, such as Domestic Violence Act, Sexual Harassment Act, and Equal Remuneration Act, laws are there, but they suffer from weak implementation. Protection officers are overburdened, internal committees often dysfunctional, and awareness among women, especially in rural area, remains very low. I have a quote from Justice Sujata Manor. She said in a judgment, "A law may be a milestone, but without enforcement, it is a milestone on a deserted road." So therefore, enforcement mechanism must be strengthened through accountability, budgetary allocation, and periodic review. Women from marginalized communities, Dalit, Adivasis, and minorities, persons with disabilities, they face compounded discrimination. The intersection of caste, class, and gender creates layers of vulnerability. So all these issues are to be addressed by my young friends, and we hope that in coming days, not years, we see a more protected, vibrant women in India.
Yes.
Thank you very much.
Yes. Very nicely elaborated with proper sections, proper law, and you have not missed any law. You have covered all the laws in such a small time, and with judgment also. So
Yes.
very thankful to you. Then I want to tell the audience कि women are still in some part of Bihar, some part of Uttar Pradesh, some part of Rajasthan. They are still in fear. So we have to give the protection. So Nani Palkhiwala Women's Right Group is for there. And we are now forming the Nani Palkhiwala Adhivakta Party. So Nani Palkhiwala Adhivakta Party membership is going on, and it is our duty to protect women. And all over India, wherever is woman suffers from any discrepancy, any problems, any harassment, we should protect her. So this is our moral responsibility. So we should be ahead for that. With that, now I request Shruti to conclude this session with the vote of thanks. Shruti, to you now.
Yes, sir. A very heartfelt vote of thanks to our esteemed guest, Senior Advocate Rachana Ma'am, for graciously accepting our invitation and delivering an enlightening lecture today. Sir, we are truly grateful for the time you took to share your invaluable knowledge with us. And I would like to extend my gratitude to our National President, Advocate Jayaprakash Somani, and the entire NPNLC team for the continuous support and guidance and to all the participants. Thank you for joining us today and making this online lecture a resounding success. Thank you
Thank,
once again, sir, for your inspiring. Thank you, and ma'am, thank you so much for your inspiring presence and for sharing your wisdom with us. And we are looking forward to our next online lecture series with Senior Advocate, Senior S. Nagamuthu, sir, scheduled for November 8th. And
yes.
additionally, mark your calendars for November as our national convener of NPNLC, Advocate Manoj Kumar Chaudhary, has organized an as an online free legal guidance camp where our very own speaker, Advocate Jayaprakash Somani sir, will be the speaker, and we hope you will all join us to continue the learning journey. Thank you. Thank you so much, ma'am, and thank you, sir.
Thank you once again.